petitioners would want to hear their petition prosecuted on the floor of the House so that they know that the matter has been adequately addressed. Finally, as I call to conclude, Honorable Speaker, this House, as per the Constitution and the Standing Order, communicates to members of the public through the clerk. Therefore, what is contained in clause 5(2), which says the committee shall in writing notify the petition of the decision of the House, we need to change the same and clearly indicate the clerk shall in writing notify the petitioner of the decision of the House. Honorable Speaker, the amendments are making it easier to present the petitions to this House. But Honorable Speaker, for the last 2 weeks since we resumed from recess, we have been grappling with the very many petitions that have not been processed. Where it's taking inordinately too long to process the petition. I want to urge the House leadership, I want to urge the committee in charge of petitions, that Kenyans are looking upon Parliament not to be a bottleneck to addressing their grievances, their problems, but to be a facilitator. And for us to be a facilitator, the committee in response to Public Petitions Committee must be brought to order and told they must process all the petitions as required under the standing order, which is within 60 days. Any delay beyond that, this Parliament should sanction the committee to ensure that the Kenyans do not petition in this House in vain. Kenyans do not also group Parliament as part of the judiciary, where even a mere matter, a simple matter, can take 10-15 years in the corridors of law in the courts without being concluded. We want speedy conclusion of matters. We are enough numbers in this Parliament. 349 is enough numbers. We could even have several committees, public petition committees, so that we expeditiously deal with petitions before us. With those few remarks, Honorable Speaker, I support the bill as presented and subsequent based on the report of the committee on the intended amendments. Thank you, Honorable Speaker.
The Honorable Member of Parliament for West Mugirango. Yes, yes. Everybody's hearing you. Proceed. You're on. Proceed. We can hear you.
You can hear me.
But you can go to the next one if you have a problem with this one. Okay. Go ahead now there.
Yes. Thank you. Yeah, that sounds like me. Thank you, Mr. Speaker, sir, for this opportunity to contribute to this very, very noble bill that is brought before this House. Mr. Speaker, I'm happy in the first instance as a practicing lawyer that we are trying to tidy up the procedures of members of the public approaching this House. Like courts of law, the Civil Procedure Act requires that before you approach any court, you must confirm that there is no pending matter relating to the same subject before any court of law. I am happy that in these proposed amendments, we are also making a requirement that whoever approaches this House must certify that there is no pendency of such matter before any court of law, or if a court has pronounced itself on the same, then a judgment regarding the same subject is brought before this House so that the House is guided as it navigates on how to resolve that petition. I am also equally happy that now, by these amendments, anybody who brings a petition to this honorable House shall be required to append evidence so that every petition should be evidence-based